Yes, sir. We are live now. Please start.
Thank you. Very good evening, friends. Welcome to the NPTEL talk on invention and intellectual property for automotive engineers. I'm glad that you could all join us today for this discussion on this very important topic, which is important not only for automotive engineers, for all engineers who come up with bright ideas, innovative and inventive ideas. It's a very important aspect that we need to protect these ideas. So a good part of the discussion today would help you to understand when you come up with an innovative idea, how you can protect the idea, and we will take you through all the essential aspects of what it takes to protect your idea adequately. So if you give me a moment, I'll just open my presentation, and then we'll get going. Are you able to see my screen now? Ram, do you see my screen?
Not yet, Dr. Shankar.
Not yet? Okay.
If there is any delay, do you want me to project it from my end?
Yes, you could do that.
Sure, let me see.
Perfect. It's in now. I'll go ahead. You can make it full screen, and then I will.
Yes, please go ahead.
So friends, as I indicated to you, the focus for the discussion today is invention and intellectual property. And I am Shankar, and I have my colleague Ram with me here. So between the two of us, we'll be introducing this topic to you. If we can move to the next chart. I'm sure you would have attended a few other talks in this series. And in fact, this is the fifth talk in the series of what we call as Mobility Engineer 2030, which is basically aimed at preparing you for the automotive industry of the future. So you have this list of a series of talks from Mahindra leaders. And the very first one was on the future of mobility, where we looked at the technologies of the future, the ones that are shaping the future mobility industry. Then we had the talk on multidisciplinary design optimization in automotive engineering, followed by one on data science in automotive product design. And the most recent in this series was the one that we had last week, which was on future skills for mobility engineers. And today we have invention and intellectual property for automotive engineers. Can move to the next chart. So this is a brief introduction to me. I am Shankar Venugopal. I'm a Vice President handling technology innovation and knowledge management at Mahindra and Mahindra. Also the Dean for the Mahindra Technical Academy. So I have held a few technology leadership roles like at Cummins, Honeywell, Dow, General Electric, and the Indian Space Research Organization prior to joining Mahindra. And by way of education, I have done my Ph.D. in material science from the Indian Institute of Science, Bangalore. Also my management education at the Indian Institute of Management, Bangalore. I am myself an inventor, been an active inventor for the last few years with a few granted patents and a pipeline of Indian patent applications. And I also been actively learning and practicing many innovation methodologies like TRIZ, design thinking, and so on. And I also been a TEDx speaker. I like to speak on technology and innovation topics. And I'm really excited about the opportunity to talk to you on this very important topic of invention and intellectual property. I mentioned that my colleague, Mr. Ram, would be covering a significant part of the discussion today. And at this stage, I want Ram to introduce himself and take over. And I would join you all back for the third part the final part of the discussion today. So with this, over to you, Ram.
Thanks, Dr. Shankar. Good evening to all. My name is Ram. As Dr. Shankar had introduced, I also work with Mahindra and Mahindra, and I'm the head of IP or intellectual property for both auto and farm sectors. I've recently joined Mahindra around 2018 or so, and prior to that, I've had close to almost 20 years of work experience across multiple organizations like GE, Infosys, Wipro, the Tatas. I did my master's and my postgraduate in mechanical from State University of New York at Binghamton, and I specialized in an area called electronics packaging, which deals with advanced microelectronics and microprocessors and design for reliability. I'm pretty passionate about the IP analytics and using intellectual property towards driving strategy and innovation across the various organizations that I've been with. I am a technophile and I love technology, so I tend to work in areas of technology innovation pretty much. Now, with this introduction, let me move on to the agenda of the talk or the plan of the talk for today. Essentially, we have three parts that we'll be covering. I'll first take you through the introduction to invention and intellectual property. Then I'll talk about some of the important inventions that have shaped today's automotive industry from the past all the way to now. What has been churning and what has been driving the automotive industry, and how does IP and this innovation tie in together? And finally, the third part of the agenda is the patents as a resource for inventors that I'll hand back to Dr. Shankar, who will take you through the final part of this plan. So let's start with the first one, that is introduction to invention and intellectual property. We have pretty much a fundamental doubt or a confusion. A lot of people have this between the three words that you can see on the screen, that is ideas, invention, and innovations. A lot of people tend to use these interchangeably, but there is a subtle distinction between all three of them. And if you see ideas on the left side, they're essentially abstract concepts whose origins are in your mind. If somebody says, I've got a fantastic idea, it's something that they've thought of, and it's still an intangible abstract form inside their mind till they actually put pen to paper and bring some tangible data or detail to it, which other people can understand. Inventions are something new that you create, which could either be a product or it could be a process. When I say product, it can involve aspects of different types of components, systems, and so on and so forth. Processes also involve your methodologies, material compositions of products, and so on and so forth. So broadly, anything new that you create will fall into the category of either a product or a process. Finally, innovations, which sets itself a little apart from invention, is the way that it builds value or usage or use value into an idea or invention. There is an invention, there is an idea, but I build value or use into it, that makes it an innovation. And if you look at the pictures, subtly you can see the distinguishing factors between the three ideas. First one is abstract, it's within your head. The second one, or components or products or systems that you can actually see, it's been made and they've been invented. The third one you can see is an interesting innovation that has come out. The safety razor is known and the Gillette razors are very well known across the world. But this was an innovation that kind of married a different usage or value to it. So apart from the safety razor itself or the razor or the cartridge itself, what they've done is, you go to a typical old barber shop, you have the fantastic advantage of the barber giving you a wet towel and a hot towel, and they actually do it as a pre-scenario or a pre-step before the entire shave act. It's a comfort factor. Now, this is called the heated razor. So there is an area under the razor which actually heats up for two different temperatures. So everybody can have a normal shave, but with the added value or use factor of having a warm or a hot shave. This is what we mean by the subtle difference between innovation to invention and how it improves actually. Building value and use into an idea or innovation or invention defines what an innovation is. Now, let's get down to the definitions of intellectual property. Now, by World Intellectual Property Organization, their definition, that is WIPO's definition, is that intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs, symbols, names and images used in commerce. Now, these are different categories under which intellectual property can actually lie into. So you have inventions, we talked about product processes in the previous slide. Literary and artistic works, we talked about books, novels, music, drama, theater, and so on and so forth. Designs and symbols, talk about logos, branding. sign work, all of these fall under the aspects of trademarks. Then finally, names and images used in commerce. You can see, look at the branding credibility aspect of it. You can look at, as you can see, the logo below Mahindra Rise, which defines what Mahindra stands for. You can see aspects of a brand value like a BMW's logo or a signage. All of these define what are the different types of intellectual property that you will actually encounter on a day-to-day, daily basis. Now, we talked about definition of intellectual property, but some people also talk about intellectual property rights. So what are intellectual property rights and what are they different from intellectual property? So this is a subtle distinction that we should understand to go further into IP or intellectual property. Think of intellectual property like any other physical property. When I say physical property, think of your house or land. You could own a house or a land, you could be the rightful owner for it, and that's a property, that's a physical property. So what rights do you have on your house? So there are some legal rights if I'm the rightful owner for my house. There are some rights that I have. Of course, I signed my sale deed and my registration deed and so on and so forth. So by the state government or by the national government, I have certain rights which recognizes me as a rightful owner of this property, which means I have the right to deal with this property and I can make use or take benefit of this property legally valid and validated by this government or by this country. So that is what the property rights or the legal rights for the intellectual property is defined by. Now, very similarly, think of any other intellectual property similar to a physical property. Like I said, your house is your physical property. Think of intellectual property very similar to a physical property for the sake of understanding intellectual property rights. Every legal right that you have for a physical property legally pretty much exists the same way for an intellectual property. So if you see the definition, intellectual property rights or IPR refers to the legal rights provided by a national government to an inventor or assignee to help them in protecting their inventions and enjoying its fully commercial benefits for a finite period of time. There are a few parts that we have underlined and I'll get to the details of those. But essentially what you're talking about is IPR or intellectual property rights refers to the legal rights provided by a national government. And the key word out here is national government simply because like your house that is present in this country is governed by the law of this country and then subsequently the state government, you cannot defend the rights of your property in this country in some other country, nor can you defend some other property in another country without actually owning it there under that country's rights. So the essence of it here is legal rights provided to intellectual property is associated to that particular geography or the national government. So all intellectual property is geographically constrained, which means if I own an intellectual property in this country, India, then it is accorded legal rights and protection as defined by the Indian government. And that is what we can take succor under. So similarly, if I own an intellectual property right in say US, then it takes protection under the US rights or the US government rights. That is what we mean by hearing say national government, which is defined by national government. But having said that, fundamental broadly, the intellectual property rights across the world are pretty much similar. Very minute process related changes might occur, but at a base level, they're pretty much similar, which is because across the WIPO and the various organizational rights and the legal rights rules that have been signed between multiple countries, we have kind of come to a place where all the rights are pretty much similar so that somebody who owns an IP in one country doesn't get completely confused and miss a portion of the rights in another country because it's drastically different. So they're broadly pretty much similar. The second part which you underline is the finite period of time. This is something that we need to understand. Most intellectual property types have a finite period of time for which they are valid. What do you mean by for they are valid? They are valid so that you can enjoy its fully commercial benefits, which is what is written in the previous part of the sentence. So if I own a property, I can take full benefit of it. I can give it out for rent, make money on it and so on and so forth. That enjoying the full commercial benefits, I can do it during the time when it's legally valid and active. That is what we call as finite period of time out here. Why do we say finite? And what happens after it is no longer finite or after the term gets over? We will come to it shortly in the next couple of slides. But essentially, during the time when it's active and it's valid, the owner of that intellectual property has enough rights to commercialize and make full benefit out of it and gain full commercial and monetary benefits out of it post which these intellectual property gets released into public domain, which means it becomes open for anybody in public to use it without any commercial restriction or license restriction. Okay, let's come to commercial benefits of IP. So as I said, rights are very similar to any other physical property like your house or your land property, can be sold, licensed, leased or given on rent, can be used as bank collateral for loans. Very similar. You have a property, you can put it in a bank, you can use it as a collateral and raise loans against it. IP is very similar. A lot of organizations that have actually utilized their IP portfolio to generate loans. Can be transferred to descendants or part of your estate as part of your will. Very similar to any other physical property. Now, let's come to some common types of intellectual property that you might encounter in your day-to-day activities. You have patents, you have designs or industrial designs, you have copyright, you have trademark, and then you have trade secrets. Now, each of them have a picture that kind of symbolizes what it actually talks about. If you look at patents, patents are usually a technical or a functional solution to a problem. Let me explain this. Most of the time we come up with ideas or invention is because we are trying to address some problem, we are trying to solve some problem. So there will always be a business problem. Now, the technical or functional solution to a problem is usually protectable by a patent. So that's what we say, patents are technical and functional solution to problem. Copyrights. I talked about copyrights and I mentioned music, movies, books at the same breath in the couple of slides at the beginning. This is what copyright is about. It's an expression of an idea in a tangible physical medium. Now, what it means is, think of an idea. And the first picture in my first slide talks about the idea, which is just an abstract concept, no form, intangible inside your mind. Yes. And then I said it becomes tangible and it has some value when you put pen to paper. And that's literally as well as figuratively. So when you express an idea, which is an abstract form inside your head, but into a tangible medium, which could be a book, a paper, or an electronic CD and so on and so forth, that expression of an idea in that medium becomes copyrightable content. So music inside my head is just an abstract concept. But if I record the music into a CD, or if I write the music onto a music score sheet, that music idea that I have in my head, but now in a score sheet or in a CD, becomes copyrightable content. Similarly, I have a fantastic idea to solve a brilliant problem and I write it down, or if I have a great, beautiful image in my mind, it's just an abstract concept. But the minute I put paint or paper, pen to paper and draw it, that expression of the idea on an artwork becomes copyrightable content. Third type that we have is trademark, which is symbols, logos, images that convey value of product or service. So you have to remember, trademark is always from a customer's end perspective or a customer's viewpoint. What it means is, it is the symbols, logos, images, signages that will instantaneously convey the value of your product or your service to an end consumer who's buying that product. For example, if I see the logo, Apple logo on a particular product, I know what is the quality that I can expect of innovation from that particular product. If I see a BMW logo on a vehicle, I know what is the quality of engineering I can expect. If I see a fantastic service company in the IT industry, we have quite a few of them. If I see their logo on a particular IT service product, then I know what kind of service value that they bring to the table. So symbols, logos, images, and signages that convey to the end consumer the value of product and service that you're offering at one shot is the value of trademark, which is very, very powerful. Trade secret, it could be a process or it could be a material that an organization or the trade secret owner wants to keep a secret so that they can get a competitive advantage over other parties. Say, for example, I have a brilliant product and there is one particular aspect of the product that I have figured out, if I tweak, it gives me a phenomenal increase in efficiency, much over any of my other competitors. Now, I can keep this as a trade secret so that nobody else knows, and that gives me a phenomenal competitive advantage over my other competitors simply because I have a product that now performs way better than any of theirs. Now, this is what we mean by saying a process or a material that is held secret to get a competitive advantage over others. We have put the example of Coca-Cola out here because Coca-Cola has this very famous trade secret called 7X, or a mysterious ingredient that they claim makes it unique and different and very uniquely tasting as compared to any other cola drink out there, which is what makes it refreshing and brilliant for the end consumers as compared to any other cola drink. So that's a trade secret that they've been holding on to, this mysterious ingredient called 7X that actually drives the value of Coca-Cola way over other cola drinks. The last type is industrial design. You can see the image of a Volkswagen Beetle car on top. The reason is similar to what a patent talks about, a technical or a functional solution to a problem. A design talks about a solution to a problem or an idea, but it covers it only from the aesthetic value or the shape or form factor. I do not get involved in the functional aspect or the technical aspect of what this idea is, but it's more covering only the shape or the form factor, which makes that system very unique. So everybody who sees this unique shape of the Beetle bug or the Volkswagen Beetle car, they know it is a Volkswagen vehicle. So that shape is what identifies to a consumer which company it is and what product it is. So that is the power of a design. Now, let's come to the benefits and risks of intellectual property. If you look at the benefits on the left side, we are talking about branding credibility. We are talking about premium pricing. We are talking about the ability to differentiate from competitors and how to create a new entry barrier for new markets. Now, simply put, all of these 4 points are connected. Reason is, suppose I create fantastic intellectual property and I actually can provide something that I can prevent my competitors from providing. So I get, like, for the example, the example that I gave of, I came up with a phenomenal improvement which gives me a better product at a higher efficiency than any of my competitors. So what you're looking at is aspects in which you can differentiate your product from your competitors. That's a third point, that's ability to differentiate from competitors. Now, think about the example that I talked about Apple and BMW. You know, a product with that Apple logo or BMW logo has a certain quality to it. That is the branding and credibility that we talk about. You build IP and you're known for innovation in this world, then your logo and your branding carries a strong value of innovation, technology, and quality, which is the benefit of intellectual property. Now, the other part is premium pricing, and it's very simple. From a commercial point of view, I have a quality value that people expect and a brand that delivers consistently. And I also provide features and technology that other competitors are unable to provide. Then I can charge a premium pricing for the same. That is the third aspect, that is premium pricing. The last part is create entry barrier into new markets. This is dependent on the facts like a lot of intellectual property rights believe or rest on one single principle. Similar to any physical property, if I own an intellectual property, nobody can use that property unless they take prior rights and permissions from me, which means I can prevent other people from utilizing the same thing unless they take rights from me, which means in new markets, if I create actually fantastic, strong portfolio of IP patents across a very crucial technology, I can prevent new players from coming into the market easily and taking my market share. Because to use that technology, they'll have to come to me for license or rights. So that's the last part, that is creating entry barrier into new markets. Of course, where there are benefits, there will also be risks. Some of the risks in intellectual property is, remember I started off by saying, if somebody owns an intellectual property, you cannot use that without taking rights or permissions from them. It comes down to that point. Usage of someone else's intellectual property without taking rights or permissions means you're misusing someone else's intellectual property. It is also called infringement. What that will result in, that person who's the owner of the intellectual property can actually initiate a lawsuit or litigation against you. So these, typical to any lawsuit or any kind of litigation cases that are filed in any country, you know there is a loss of time, effort, and money, and there is no guarantee that you'll win the court case at the end. There is a loss of branding and value, and at the end of the day, there is also loss of business continuity and revenue, because as long as an intellectual property case is going on and there are injunctions filed by the person who's actually contesting against you, they'll prevent you from selling the property that is being contested. Say, for example, you have a product that you're ready to launch into the market, but one of your competitors has sued you saying that you have actually copied their patent or their intellectual property. Then you cannot sell that product that is in question right now of being infringing in the market and make money till the court case gets settled. So this essentially means you can sit on a lot of inventory of product, but you might not be able to sell it till we resolve the court case. And you know how long those can take. So this can lead to loss of business continuity and revenue. So let's go next to the definition of what are patents. A patent is an exclusive right that is granted for an invention, which is a product or a process that provides in general a new way of doing something or offers a new technical solution to a problem. This is the definition given by WIPO, that's the World Intellectual Property Organization, on their website. Let's break it down into small parts. A patent is an exclusive right granted for an invention. So we talked about inventions, which are either products or processes. Now, this patent is an exclusive right that is granted. We talked about this right is granted, the IPR rights are granted by a national government. So if I get a patent if I get an Indian patent, it means the Indian government is recognizing my invention and it's giving me a patent saying that I am the rightful owner of that patent or that feature or that technology and I have certain rights. Now, what could be my invention? It could be a product or a process that provides in general a new way of doing something or a new technical solution to a problem. So this is what I talked about saying a patent in the previous slide where we talked about types of intellectual property. Patent is a technical or a functional solution to a problem. This is where it comes from. So typically your invention is either a product or a process which provides a new way of doing something or a new technical solution to a problem. And the patent is that exclusive right provided by the national government for that invention that you are the rightful owner of. Now, there is something that I've written out here, balance of privileges. So the rights are not all free-flowing and infinite. There are terms, there are boundary constraints, and there are restraints to it. So let's go through the balance of privileges for what are the patent rights. Patent rights are not valid infinite. They are valid for a finite lifetime, that is 20 years from the date of filing of your patent application. Once you file a patent application, it means it requires public disclosure of invention, because when you file for a patent application of your invention, you have to describe your invention in detail, and it will go into the Indian Patent Office. They'll examine it, and when they grant your patent, it will also be put up in their patent database for other people to look at and understand, and also look at how it is actually benefiting the technology and the field. Post lifetime, it is made free to public for unrestricted usage. This is what I talked about saying. After the finite lifetime, what happens to a patent? So till the lifetime is valid, the owner can have full benefits, can benefit fully during the lifetime, which is the next point here. But post the lifetime, it is made free or open to public, so anybody can use it without unrestricted usage like licenses and so on and so forth. The final point is patent rights and negative rights, and this is a very, very critical point. What it means is, unlike a positive right that enables you to do something, patent rights are usually called negative rights because it prevents you, it helps you prevent others from doing something of yours. So you get a patent for your invention, you can actually prevent others from doing the same thing unless they come to you for rights for your invention. Because this entire right of yours is about preventing others from doing the same thing that you have a right for as an invention, it is called a negative right. So if you have a patent for a particular invention, what it means is you have a right to prevent others from utilizing what is in it unless they come to you for rights and permission. And the last point, which is usually what we call as the bottom line, usage of others' patents or intellectual property without their permission or rights is called infringement, which can be followed by lawsuits or litigation. Now, the next question that somebody might ask is, how do I get a patent? So I have a great idea. Is that valid for a patent? I have a fantastic invention. Does it qualify for a patent? Okay. So let's look at what we call criteria for patentability. Criteria for patentability is very simple. We call it the NUN criteria or the NUN criteria. The first N stands for novelty, which means it has to be new or novel against state of art. It should not be available earlier or prior in public domain. Now, state of art is a term that we have put in quotes out here. What it means is, if there is a technology, if I come up with an invention in a particular field, it should be new or novel and nobody should have seen it. It should not be available already in public domain. State of art essentially means what already exists in the world currently or in public domain currently in that field is called state of art. So it has to be new or novel against the existing state of art. It has to be improved or newer than that. That is the criteria for novelty. Utility, it has to have utility or usefulness value. Final N stands for non-obviousness, which means the improvement or advance that you're doing over the existing state of art should be not obvious to somebody skilled in the art. What it means is, if you're working in the field of, say, automobile engines, and say a particular electric engine is already known right now, my invention is an improvement on the electric engine. But that improvement or the delta or the improvement or the advance that I'm talking about should not be obvious to somebody who is skilled in the art of the automobile engine. If it is very obvious to somebody who is skilled in that art, then this factor called non-obvious will kick in and you will not be given a patent. Simply put, if I can give an example, if I have a product that does function A, if I have a product B that does function B, and I combine both of it and put it in a single body, and it still does only A plus B function, that means you're just putting it into one single body, but it's not doing anything new. It is still doing just A plus B. So for somebody who is skilled in that field, it is a very obvious combination. So therefore, it becomes obvious. You will need to get past your delta or the improvement that you are doing on state of art should actually not be obvious to somebody who is skilled in the art in that field. This is a very subjective parameter, but it's also one of the most critical parameters on which patentability rests on. Now, we will move to critical elements of patent, which will allow you to identify the important aspects and information in a patent that you need to be familiar with and you need to understand to move forward. So I've taken an example of a US patent, which you can see it on your left side. Most patents follow the similar structure. The components will be pretty much similar. So you won't feel too much of a disorientation or confusion when you go from, say, an India patent or a US patent. But the key sections that I would like to draw your attention to is bibliography, abstract, background, summary, claims, and drawings. Now, each one of these sections has a particular function that they carry out, and they carry a lot of information that is absolutely crucial and important for all of us to understand the criticality of the patent. Let's go one by one. So this is the front page of a typical patent. It's a US patent. You can see the various areas that I've circled. So if you see the left part, this is what we call the bibliography of the patent, which means it contains critical aspects, or the front page contains the bibliography of the patent or critical data points of the patent, which will give you various details about what and who the patent refers to and relevant to. So if you see the leftmost thing, it talks about the title is United States patent, which essentially defines the geography or the country to which this patent belongs to and where it is protected. This side, you can, on the right side top, you can see patent number, which is essentially the number of the patent which you can identify it by, and date of the patent, which is essentially when the patent has got granted. On the left side, you can see below the United States patent, there's another red circle that talks about the title of the patent, which you can understand what the patent or the invention is about. You can see the list of inventors who have worked on this patent or who actually have created this idea or this invention. And then finally, assignee. In this case, you can see it's Mahindra and Mahindra Limited. Now, there is a subtle distinction between inventors and assignee. The way I would put it is, inventors are like the authors or the creators or the people who have created or invented the invention or the idea. Assignees are the owners of the idea. A lot of times, these can be one and the same, but quite a few times they can be very different. Simply put, if there are technical paper publications and so on and so forth, if you're part of an organization and you publish, you might be the author for it, but the owner of that paper could be your organization, which could be a university or it could be a company. Similarly, you write a novel, you're an author and you write a novel, you would be the author, but the owner or the ownership rights of that book or the novel could belong with your publisher. Similarly, for a patent, I could be an inventor and I come up with this idea, but I'm an employee of the organization Mahindra and Mahindra. Therefore, assignee refers to the owner of this patent, and inventors are the people who have come up with the idea or the invention of patent. Now, who has the legal rights to protect the patent and take benefit of the patent? It rests with the assignee or the owner, because they are the legal owners and they can deploy the legal rights of this patent. The final section or the circle that I want to draw your attention to is at the bottom right, which is abstract. Abstract is usually a paragraph that you can read, which is written in typical English language, which gives you an abstract of what this invention is about, very similar to abstract for any technical paper publications or journals that you might find. Now, once you have gone past the bibliography, let's look at two other sections that we need to draw your attention to, which is background and summary. So when you go to the first page of the patent after the bibliography, you go to the next page that is there on the patent. This is the structure of format, and you'll find a title saying background. Background essentially refers to what we call state of art. What it means is, If you're paid, in this case, you're talking about system for this title of this patent is about system for providing continuous lubrication to engine. So it's about an engine. So the background gives you all the necessary background details about this field, this industry, or the problem that you're trying to solve. What have people done so far? What is the state of art? What kind of solutions exist so far? And what are some of the issues that still exist, which you're trying to address? So this is the background of the invention, which covers all of these details. Summary of the invention on the other side will capture all aspects of your idea, not state of art, not the background, but your idea. So while the background covers all aspects of the industry, the problem, how many people have worked on it so far, what are the different solutions that exist, what are the gaps, summary of the invention will focus on what is the summary of your idea and your invention, and what problem are you solving, and how are you solving, and how is it beneficial. So when you understand the background and you understand the summary, you can essentially look at state of art, and you can understand the delta or the improvement that you have done to address the gap in the state of art. So these two put together will help you understand the novelty and the non-obviousness of your idea. The last part that we look at is the patent claims. So as you go down to the patent at the end, you'll get a section called claims. It will also be preceded by a typical language saying what is claimed or we claim. Under this, you'll have numbered set of systems, which are essentially. So think of claims as the legal boundary of your rights. If you have a house, your rights on that property is not infinite across the entire road. It is, if you have a house, you have a fence around your house. The fence defines your property geographical dimensions, which is where your right starts and ends. Similarly, the claims are essentially the boundary of your invention. It tells what is the scope of your invention, what is the focus point of your invention, what and all does your invention cover, and this is where your legal rights are. Your entire legal rights to your invention is covered by what is kept in your claims, and it covers the scope of what your invention is about. So this is very, very crucial to understand exactly what your rights are of which part of your invention. Finally, we'll cover an aspect of who is an inventor. An inventor is one who's contributed significantly to the concept of an invention. An inventor must have contributed to at least one of the total claims defining the scope of invention. Simply enabling the idea to build a finite element model or a mathematical model or abstract systems cannot enable one to become an inventor. One would have to contribute to the technical improvement or modifications to an idea concept to be considered for inventorship. These are 4 rules that we'll apply for inventorship. You have to remember that to qualify for an inventor, each country has slightly varying set of rules which will define what is a true inventor. But broadly, these 4 points cover what will enable you to become an inventor. You need to have contributed significantly to the concept of an invention or an idea. If there's a particular invention, there's a particular idea, you need to be one of the few people who has contributed significantly to any one of the features or multiple features of that idea or invention. You must have contributed to at least one of the total claims. We saw the list of claims in the previous slide. You should have at least contributed to one of the claims in that invention, which enables you to become an inventor. So somebody comes up with a great idea and it's a fantastic invention concept. But what I'm doing is I'm just building it in the laboratory to show it works. So I am not contributing to that idea or concept. I'm just enabling it to see if it works. Therefore, I do not qualify to be an inventor in that case. But while building or while enabling this, if I come up with further technical improvements, then I can actually qualify. So here the point is, if I just build finite element model and show it that idea works, or if I build a lab scale prototype model and show that idea works, but I do not contribute anything to the technical concept of the invention, then I don't become an inventor. But while doing these things, if I actually add to the improvement of the design or to the concept of the invention, then I can also become an inventor. So these fundamentally are the 4 rules that define who can become an inventor, who is not an inventor. That concludes my first part, which is about introduction to invention and intellectual property. Very briefly, we will go through the second part, which is critical inventions that have shaped today's automotive industry. It is a list or a vision or a view into what has happened over last, I think we can start off with probably the steam engine, which will be 1700s. So think of it as around 300 years or plus. How the automotive industry has been defined by certain inventions. And believe me, there have been a lot of patents across these inventions, and they've gone through their lifetime but they are still considered very valuable and important because of the role that they played in the automotive industry and how it has shaped over the years. It all began with the steam engine, 1700s. We talked about James Watt, and this started the point where we talked about an energy being harnessed for motion, for getting a person from place A to place B. Of course, the internal combustion engine. This brought an economy to the system. It made automobiles affordable. Of course, it was also the gas engine, atmospheric gas engine, was followed further by the diesel engine, which essentially made it even more efficient and cheaper. So this comes in, this would have been probably around 1800s. Then we looked at safety aspects. Can we imagine a life prior to anti-skid braking systems? What these enable is to ensure that the tire always has traction with the surface under various conditions to prevent the wheels from locking up and going into a skid. So these are so crucial because they add in safety factor to our everyday activities that we carry out with our automobiles. Another aspect of safety, airbags. In some countries, airbags might not be a mandatory requirement across all segments of the vehicles, but slowly but surely we are moving towards a system where even a base level vehicle should have the minimum safety of airbags and how important they are and what role they play during crash. Hybridized drivetrains. First came the automobile engines. You have your ICEs, which is gasoline, then you have your diesel. Then, of course, came the hybrids. Mixing and marrying of multiple technologies or hybrid systems, which brought in fuel efficiency. Seat belts, the 3-point seat belt system, additional safety into an automobile and protection for our family and our loved ones. Catalytic converters, emission control. Over a period of time, we saw that based on the fuel that we used and based on the systems and the efficiency and how efficient they are, there could be a lot of noxious gases as emissions that can go into the atmosphere and thereby pollute the city in which we drive these vehicles. So catalytic converters became the first step in treating these emissions as they went out of the vehicle to break them down into harmless gases as they go into the atmosphere, thereby cleaning and making our cities a little bit cleaner and purer. GPS, Global Positioning System, navigation. Can we imagine a vehicle right now or a smartphone without touching Google Maps or any kind of positioning system or navigation? Smart key and auto start. Now more and more electronics are coming in and a lot more functions are getting into your vehicles. Earlier, the key was only to put it into the keyhole and open the door. Now your key has everything from locking to generate anti-theft alarm. It also has an engine immobilizer. Everything it's getting packed into your key due to advances in other technologies like say Wi-Fi, Bluetooth, RF and so on and so forth. Electric cars. And interestingly, the first electric car actually came out in 1884 in London. Electric vehicle, I would say. And then its new version that we see nowadays with the Teslas and all the electric vehicles that are out there, which is currently the future of where we are going green and going clean. Cruise control, comfort. For those long drives where you don't want to put a lot of stress and effort into your hands and your driving aspects, cruise control was a brilliant invention that came up that actually enabled a person to bring in physical relief and bring in more comfort into long distance driving. These were some of the patents or innovations that covered the automobile industry and drove them towards the future as we saw. With this, I finished the top two sections of this talk and I will hand it over to Dr. Shankar, who will take you through the third part of the session. Dr. Shankar. Dr. Shankar, please go ahead. Kindly hold on. I think we have some technical issues.
Ram, can you hear me?
Yes, Dr. Shankar, I can hear you now.
Okay. You could present the slide and I will continue.
Sure. So let me present.
So friends, I'm sure you have heard about what it takes to protect your idea in terms of having a patent around your idea. You also have seen what are the various inventions that are actually shaped the automotive industry of today. And this has happened over the years due to the contribution of many inventors and their effective strategies to protect their ideas and scale it up and make it all available for us today. So that's how the automotive industry has shaped. So the final part of this presentation, what we want to discuss is if you are an inventor, you want to come up with those brilliant ideas, and then you also want to protect them by patenting them. How patents itself can to help you to come up with good ideas. So that's the final part because we have looked at protecting ideas, but now I want to look at creating ideas using the information that you get from patents. So that's how I have titled this final section as patents as a resource for inventors. Okay? So I will be very brief so that we keep some time for the Q&A also. Okay, if we can move to the next chart. Yes, the very first thing patents can help you is to spot what are the important problems in the industry, especially if you're a student and you're ready to enter the industry. I'm sure you'll be curious to know what are those important problems that the industry is working on. And the best place to look at that is through the patents. Because a good number of patents are actually problem solution pairs. An important problem that the industry is facing and the solution for that problem is what you will find in many of the patents. So when you look at the patents and start studying them in depth, one thing that will become very clear to you is what are the problems that are important to the industry. So if you choose a few automotive companies and look at their patents, it will be very clear as to what are the problems that these companies are working on. And you can do this now. We can do this 5 years back or 10 years back to see how the various problems have been solved and how one problem has led to the next problem. Okay. And you'll also know who is interested in solving which kind of problem because each patent, when you look at the assignee, you know which are the companies which have filed this patents. So you would know what are the technology paths different companies are taking and who is interested in solving which problem. For example, one company may be interested in creating vehicles powered by hydrogen. So you'd see that their patents are more on hydrogen-based design of hydrogen-based vehicles. So fuel cells related work. Some other company is purely interested in, say, battery-powered electric vehicles. When you look at their patents, you will see more patents coming on the design of electric vehicles and improving their performance. Like that, it's very easy to find out who is interested in solving which kind of problem. And also you would see that the interconnection between different problems. When you look at patents filed by one particular company in a specific problem area, you won't find just one or two patents, you'll find multiple patents. And when you look at all this, you'll see how these problems are interconnected. How you have to solve all these problems if you want to put this technology in a product and deliver the kind of performance that the customers are asking for. So although also I mentioned that you can see the evolution of problems and the evolution of industries. And of course, when you look at the names of the inventors, you'd also know who are the key contributors to this particular technology over the time. So you know whom to follow. And when they are teaching some courses or when they are giving some talks and conferences, you'll be able to know who they are and specifically follow their work and their ideas. So all this rich information is available when you look at patents. This is something very, very important. And also on the right side, I have shown you just by the patent numbers, how many patent applications are being filed across different areas. You're able to see which of these domains are active today, which is how it was. Similar data exists across years. So we can see how each of these domains and the corresponding industries have evolved over the years. So this is a quick snapshot of what are those hot areas, hot industries, hot topics, and the hot problems to work on. So entire cross-section of all this you will get to know by just studying the patents. So this is a very good starting point. If you're just planning your career in the industry, just want to know what kind of problem I should start working on, this is the best place to get started. This is about the problems. Let's look at the next chart, which will show you it's not just problems. Since it's a problem solution pair, you will get to know about variety of solutions that various inventors across different countries, across different companies, across different industries have used to solve the problem. You will know what are the current solutions that's being pursued by the industry. You'll also get introduced to new concepts. And also you'll be, when you study multiple patents, you'll also be able to compare the various solutions that are being offered, and you'll try to analyze and understand how one solution is better than the other. Also, since somebody who is interested in commercializing these technologies are the people who are actually patenting it, and it's very obvious that these solutions that you're talking about, most of them would be scalable and manufacturable, because they would also talk about the implementation aspects of these ideas. So instead of starting from scratch and trying to solve, if you actually study a few patents in that particular domain, you'd be able to focus your efforts on those solutions which are novel, which are scalable, which are manufacturable. So a study of patents can easily lead you to better and better solutions, because I'm sure you would have heard Ram talk about the criteria for granting a patent. One of that is there should be an inventive step. There should be some new knowledge that gets captured. So when you study patents, naturally you're going to get exposed to so much of new knowledge in the form of these inventive steps. So with that background, when you try to solve a problem, you'll always come up with a solution better than what you would have done otherwise, even if you are the best domain expert in that particular field. That's where the study of patents can help you not only with identifying the right problems, the important problems, but it will also lead you to better and better solutions. You can move to the next chart. Here, something very critical, very useful is the study of patents over time will also help you to understand the evolution and also what's next in terms of predicting the trends. Because we can see how the industry is moving towards, what kind of technology is becoming more active, and what is the future. So because if you're looking at 5 years, 10 years, and 20 years ahead, if you want to see which technology is going to become more important, where should I focus more, again, you would see this. Because I'm sure you've all heard of the technology S curves, where a technology starts small way, picks up momentum, and then after a few years, the value from the technology keeps on rising. But after a few years, there is a saturation, there is a plateauing. So you can't extract anything more from the technology. That's when the next technology comes in, and then the next S curve happens, and there is a jump from the current to the next S curve. These are the technology S curves. So if you try to plot the number of patents filed over time in these technologies, that will also follow a very similar S curve. Initially, there will be few patents because the technology is new. Then there will be a lot of patents as the technology picks up momentum. And when everything that can be done is done and everything is already patented, then there will be a saturation, there will be a slowdown in the number of patents appearing in that particular space. So that will follow the same S curve as the technology S curve. That's how a study of patents will also help you to predict the trends of technology. You can move to the next chart. So we talked about problems, solutions, and trends. And more interestingly, the study of patents will also reveal the convergence that is happening across multiple technologies, convergence across industries. See, what I show on the right side is a prediction that Nicholas Negroponte from MIT Media Labs had made in early 1980, that these three fields of computing, communication, and content will all converge. And today, we see that in the It's almost one and the same. The three circles have now overlapped so much that you don't see the three circles anymore. It's just one circle. Okay. And when you study the patents, you would see that there will be patents cutting across these domains, computing, communications, and content. And also in terms of people, the co-inventors, you'll see people from multiple companies are representing all these three industries, collaborating, coming together to create these patentable ideas and being co-inventors in such patents. So by the study of these patents, you will see how ideas are converging, how the technologies are converging, how the industries itself converge. And you will also get to know who is collaborating with whom, what are those strategic partnerships that exist across the industry. So this is again a rich source of information which you can easily get through study of patents. Otherwise, it's very, very difficult to find out. Without patents, it's impossible to find out this kind of convergence that is happening in the industry. If you can look at the next chart, here we have talked about problem, solution, trends, and convergence. Now let us look at what more you can get out of patents. So the discussion has always centered around the emerging technologies in the automotive space, which is electric, autonomous, and connected vehicles. So on this chart, what I show here is the unbundling of the autonomous vehicle itself. If you look at key sub areas, which is in terms of the technologies around the perception itself, and then the localization and the complete systems, you would see that there are multiple players because we have talked on quite a few occasions. I have mentioned to you how the electric, autonomous, and connected, these three technologies are converging together to create the mobility of the future. So when this happens, actually no one player will have the bandwidth to work on subsystems across all this. So naturally it will bring multiple companies together to create this product, which is the connected car, an electric car, and also autonomous car. So there will be definitely multiple players and there will be IP sharing models that would come up to encourage the collaboration across these players. And there will be multiple technologies. Sometimes there could even be competing technologies. If you look at perception, you see that light detection and ranging, LiDAR, is one area where you would see a lot of patent activity. Then there will be a lot of patents being filed on cameras and computer vision, both on the software and hardware. Then the radar, the data and simulation, and a vehicle to vehicle, vehicle to infrastructure, variety of V2X kind of communication systems. All those things you would see happening when you look at the perception perspective. Same way from a localization, you will see a lot of activity happening around the maps themselves because you need very precise maps if you want an autonomous vehicle to have a reliable performance. Then, of course, there will be a lot of patents that you would see happening in the vehicle systems itself, complete autonomous driving enablement, and also the vehicle, the complete vehicle, the various component technologies that would go into making this vehicle completely safe and reliable and with complete autonomous features. So when you look at patents in this autonomous vehicle, these are the kind of trends that you'll be able to see. And these are the multiple players that you would see who are actively working together to create this autonomous vehicle. This is just one example of how complex and how interesting this whole space is becoming. So if you are planning a career in the autonomous vehicle industry, then you should be basically preparing yourself for this level of scale and complexity. We can look at the next chart. This is where I have shown the number of patents around autonomous vehicles, how they have increased over the years. Okay, look at this, 2009 and 2019. If you compare, you can imagine how much of intense research and IP creation is happening in this space. Also, when you look at these patents and go a little deeper and understand, you will see that there is a distribution of these patents across three engineering domains, which is electrical engineering, mechanical engineering, the electronics, and the instrumentation. So this is something that I have been telling you about, that if you're a mechanical engineer, you need to pick up skills in electrical and electronics and vice versa. So the Mobility Engineer 2030, which is the theme of this talk series, is one of the key facts that we remind you again and again is the mobility industry of the future would need people with skills across multiple engineering domains, mechanical, electrical and electronics, and computer science, which will be very evident when you look at the kind of patents that you see in the autonomous, electric, and connected vehicle domains. That's the reason why I thought I'll share this data with you to see how this is already happening in terms of patent creation in autonomous vehicles. If you look at the next chart, I put something in terms of so far we talked about patentable ideas and patentable technologies. One more aspect, this example of connected vehicles, I want to introduce to you is the importance of technology standards. Okay. Here you would see that when you talk about a vehicle-to-vehicle communication, when you look at different levels of connectivity, if multiple cars have to talk to each other and understand, you will be able to appreciate the importance of standardization in the various protocols. You would see multiple standards that are coming into picture when you look at a connected vehicle. So this brings us to yet another important topic of discussion in the intellectual property space, which is about the standards. And if you can look at the next chart, I have put something on what I call as standard essential patents. This is a very important topic for you to understand if you are going to work on connected vehicles. So standard essential patents are basically patents that cover certain technologies which are becoming standards. And if you have one such patent, everybody has to license that patent because it's part of a standard. They cannot have a product without that. So when you have to license out such a thing, or either you could be the person owning the patent, or you would be the person who needs a patent because you need it for your product. In that case, when I talk about standard essential patents, there are certain legal frameworks that comes into picture, one of which is FRAND. FRAND is fair, reasonable, and non-discriminatory. That means if you have a standard essential patent with you, you should be very fair, reasonable, and non-discriminatory when it comes to licensing this standard technology to others. Now, this is important because patents are there to help a technology to grow and for the industry to come together and create products that will benefit the customers. Under no circumstance should patent become a block. Under no circumstance it should delay or slow down the growth of a technology. This is against the basic philosophy of patents itself. So that's why when you talk about the standard essential patents, we also talk about FRAND, which is fair, reasonable, and non-discriminatory use of the standard essential patents. This is just something I thought you should know if you're planning a work around autonomous and connected vehicles, especially. You can move to the next chart. Yeah. So we are just about 7 o'clock. So I'll just spend 2 minutes and wrap up this discussion. The best place if you are looking at cross-pollination of ideas, if you want to bring ideas from other domains into the automotive domain, the best place to look at is patents. Because when you look at a similar problem that has been solved in another industry and you study it, and then you try to adapt it to solve a problem in the automotive industry, there will be a seamless cross-pollination of ideas that happens. This can be in terms of either product features or process features. You could do at multiple levels. But what this makes possible is to bring a fresh idea that has worked in some other domain into the automotive domain. And either you could work on that and come up with your own patentable ideas, or you could go ahead and license the technology from whoever owns the particular patent and adapt it for solving your problem. But it brings a lot of freshness into the ideas that we pursue in the automotive space when you use patents and consciously look for opportunity to cross-pollinate ideas. So building on this topic, I just want to introduce you to a whole new field which has been built based on cross-pollination of ideas. And that's on the next chart, which is where I want to introduce you to the field of innovation, specifically systematic innovation. And this is a topic that we are going to talk to you at great detail as a separate talk in this series. But what I want to tell you today, this whole field of systematic innovation, which is TRIS, that we'll be talking to you, is based on study of patents. The inventor of this method, Altshuler, actually studied a very large number of patents to come up with inventive principles and a beautiful approach, a very, very systematic approach to solve technical problems and come up with innovative ideas. So what this offers you is the power of knowledge and the power of imagination. By using TRIZ, you'll be able to bring both together. Typically, when you have less knowledge, you'll be very imaginative. And when you have more knowledge, the chances of you being imaginative also comes down drastically. So it's always a struggle to have a good amount of knowledge and also a good amount of imagination. So people struggle, especially experts struggle a lot when it comes to that. And TRIZ allows you to do that. It allows you to be both knowledgeable and also being imaginative so that you'll be able to come up with innovative ideas. For those of you who want to know more about it, please do attend our talk in this series, which is Systematic Innovation for Automotive Engineers. I think we'll be coming back to you in a couple of weeks with this talk in this series. I just have one more chart in this, the next chart. This is where the whole field of TRIZ, Altshuler studied about 200,000 patents in great detail. Imagine those days there was no internet, there was nothing. He had to go to the patent office, pull out these patents and study. And he studied 200,000 patents and found that there are only 40,000 patents which really have inventive ideas amongst this 200,000. So he studied those 40,000 patents in greater detail and extracted 40 inventive principles which can be used by all of us to solve a whole variety of problems in our own domains and come up with innovative ideas. These 40 inventive principles are the basis of the entire systematic innovation method called TRIZ. And this was possible only because Altshuler studied this 200,000 patents. So this is just a sample of how much study of patents can help us when we are on the innovation journey. So this is just like a trailer for a movie that's coming up next, which is our talk on systematic innovation for automotive engineers, which will happen in a couple of weeks. So with this, I want to wrap up the discussion on how a study of patents can actually help us as automotive engineers to come up with very, very innovative ideas. So today, friends, we talked about invention, ideas, inventions, and innovations, and understood a bit about intellectual property and how we can protect our ideas. We also talked about the various inventions that have shaped today's automotive industry. And finally, we talked about how patents can be a resource for us to come up with inventive and innovative ideas. So I think we would stop at this stage and look at the kind of questions that you have posted so that we will spend maybe another 10 minutes answering these questions and then we'll wrap up the session for the day. So Ram, if you can open the link and pick a few questions that we can answer right now. And in the interest of time, the rest of the questions we will answer through email.
I'm just opening it.
Yes. We will try to answer at least 3 or 4 questions. Sure. And the rest we will respond by email.
Okay. So let me share my screen again so that, I think, okay, let me read
this. Read it out. That's still okay.
Okay. Let me very quickly see. Does the practical field develop more patents across sectors or the academic field in India? Do company acknowledge patents if someone use patents from academic field? There is one question from Mayur Kriplani from Pune.
Sure.
Okay.
So patent is a patent, whether it's whether the inventors are from academia or from industry. A patent is a patent, and whoever wants to use that patent have to definitely approach the whomever owns that patent and license the technology from them. That is the only way you can use the technology, let alone acknowledging. So a patent doesn't distinguish whether it is from academic domain or from the industry domain, or it can be a mix of inventors from both also, which we very often see when industry and academia collaborate. You want to add to this, Ram?
No, you're absolutely right, Dr. Shankar. So it usually comes from all aspects, both academia and industry. depending on external factors across the country, which could be how advanced or lead our academic institutions versus how strong the industry is also taking forward, and also the strong collaborations between these two parties, you will see always a shift between one group to another in terms of the patent filing trend. So this can come from any direction as well as from any groups, and it's just an indicator of what are the critical problems that are being solved. One thing that generally happens across most countries in the world is a lot of forward-looking problems which have a huge lead time tend to sometimes look at from an academia point of view. So academia tends to look at least 10 years, probably 15 years down the line, they try to look at some problems. Whereas sometimes industry can be more focused on short-term problems. It's not necessarily the truth always, but this could be a generic factor that can come in as a difference between academia to industry, where academia could lead and industry could look at short term. So this could also define the type of patent filing that happen across these two groups in any organization or in any industry or in any country.
Absolutely. Sure.
So another couple of questions that I have from Arya Jyoti Dyo from Bhubaneswar. One question is, may I know whether trade secret is protected for a finite period or lifetime? Interestingly, as the name suggests, if you can keep it a secret, you can do it infinite. There is no finite lifetime for a trade secret. As long as you protect it and as long as it's a secret, you can hold on to it. The flip side is, if somebody finds out about the trade secret, whether knowingly or unknowingly or by chance also, then it is no longer a solitary trade secret with you. Then somebody else also has access to the same thing and they can also take benefit of it. So that is the pros and cons of having a trade secret, which can have an infinite lifetime. But the minute it's out, it no longer satisfies the criteria as a secret because someone else also knows it and someone else can also utilize it to get the same benefit. Then one question from Mr. Kailash Pandey from UP. If I have an idea and it's not practically tested yet, how to take advantage of IP? Dr. Shankar, would you want to?
Sure. Yeah. So when we talk about patenting your idea, we need to have the concept and also what we call as a reduction to practice, which is a proof that your concept actually works. Okay. So you cannot simply file a patent on an idea alone. You need to have some proof to show that your idea works. So this proof can be some experiment, prototype that you have made. It can be something physical, or it can even be a model or a simulation that you have run to show how your idea works. But it needs to be something more than just the idea. There should be some proof to show that the idea actually works. So if you have both this, then maybe you'll be able to go ahead and apply for a patent and protect your idea. But if all you have is only the idea and nothing else, then I don't think it is possible to protect it. Maybe Ram would be more knowledgeable on this and he'll be able to comment more on this.
Sure. So it's pretty much what Dr. Shankar mentioned. So at the end of the day, when you have an idea, as I mentioned also in the slides, it's an abstract form. You will need to elaborate how you'll enable that idea or how you'll make it work. And this could be done through our standard laws of physics and nature and so on and so forth. You have to tell how to enable it, how does it work. It cannot be, for example, I can have an idea about time travel, but by current laws of physics and nature, that is not doable. So it is only an idea. There is no enablement to it. You will need to bring in this enablement, and it can be through different things. It could be models, simulations, it could be prototypes, it could be constructed dioramas. These are various ways in which you can show how it works so that somebody who reads that patent is also able to recreate it without undue experimentation. So this is what is minimum required, at least to file for a patent. I think those kind of cover the list of questions that we have.
So it's also 7:15. So we'll stop at this stage. And if there are any more questions that come up, we will respond to them by emails. That should be okay. You don't want to exceed the time too much. So I think, friends, you got a fair idea of inventions and patents today. And Ram and I will always be available to you. You have our emails with you. So feel free to reach out to us. If you have an idea that you want to patent, we'll be able to advise you how to go about it. So this has been a great session interacting with you all today. We appreciate your interest in knowing more about it and the kind of questions that we came up also. It was very nice to take those questions. And we really look forward to each one of you becoming an inventor and having your own patents by the time you come to join the industry. It'll be great for you to have a patent of your own. So we want to wish you all the best and study those patents, look for those important problems and start thinking about them. And then you may very well get a patent for your idea. And then that will really amplify your chances of getting into the industry of your choice. So all the very best, friends. Take care and have a good weekend ahead. Bye.
Thank you.